This is Barry Zalma speaking for Claim School Incorporated's blog, Zalma on Insurance. Today we're going to speak about why a dental insurer was able to fairly deny a claim and avoid allegations of defamation because the comments were made that were true and were made without malice. Plaintiffs, SmileDirectClub and Smile of Tennessee PC sued Delta Dental and argued that they made sufficient allegations of malice based on Delta Dental's knowledge of the falsity and or reckless disregard of the truth of statements about the do-it-yourself nature of plaintiffs' clear alignment therapy. Basically, do-it-yourself orthodontia. In SmileDirectClub v. Delta Dental, a December 8, 2022 decision of the Illinois Court of Appeal, the Court of Appeal resolved the dispute. Plaintiffs offered dental support organizations services and a medtech platform that enable licensed dentists and orthodontists to treat patients with mild to moderate malocclusion with clear aligner therapy using a teledentistry platform. Defendant Delta Dental is a nonprofit association of 39 member companies that provide Delta Dental branded dental insurance and dental plan administrative services to insureds and employers. Delta Dental, by and through its affiliated member companies, provided insurance for approximately 75 million people nationwide, and approximately 25% of SDC's customers were insured by Delta Dental affiliates. Plaintiffs offered the dental service of aligner therapy as a remote alternative to traditional in-office orthodontics. They advertised their product in part by emphasizing the convenience they provided to customers by offering a dental care solution that did not require visits to traditional dentist offices. In 2017, the American Dental Association passed Resolution 50, which strongly discouraged the use and the practice of do-it-yourself orthodontics because of the potential harm to plaintiffs. The ADA argued that self-made dental impressions were almost inherently of little clinical value because it was difficult for a trained, experienced professional to make a good dental impression of a patient's teeth, even in the controlled environment of an office equipped to take and retake such impressions, and it is important to be able to see and examine the patient while the impressions are being taken. Delta Dental, sometime after the ADA statements, issued a policy directive to its members for the denial of all claims for coverage of SDC clear aligners. Accordingly, Delta Dental members issued insurance claim denial letters to insureds seeking coverage for treatment with those clear aligners. The denial letters referenced in varying terms the self-application and mail-order nature of SDC services as the reason for the coverage denials. In 2020, plaintiffs sued. Ultimately, plaintiffs filed a 7-count third amended complaint against Delta Dental only, alleging that Delta Dental and its member companies wrongfully denied insurance benefits to their insureds for the cost of plaintiffs' dental aligner therapy as part of a conspiracy to defame, disparage, and interfere with plaintiffs' teledentistry businesses. Plaintiffs' allegations that Delta Dental acted with malice are based on Delta Dental's and its members' alleged knowledge that the aligner therapy was overseen by licensed dentists and SDC's argument that the ADA has a history of anti-competitive behavior. On January 25, 2022, the Circuit Court dismissed counts 1 to 6 of the third amended complaint with prejudice, ruling that a qualified privilege applied to the member company's statements about the self-administered nature of plaintiff's aligner therapy because those companies had a legal duty to explain to their insureds the reason for the company's denials of the insured's insurance claims. The court also ruled that plaintiffs failed to sufficiently allege malice to overcome the qualified privilege, given the evidence of the public controversy over the safety and efficacy of plaintiff's aligner therapy. The court, in reaching its decision, reported that a motion to dismiss requires that the trial court accept all well-pleaded facts in the complaint as true and draw all reasonable inferences from those facts in favor of the non-moving party. The court may consider only those facts apparent from the face of the pleadings, matters of which the court can take judicial notice, and judicial admissions in the record. Plaintiffs first argued that the statements in the insurance coverage claim denial letters that members of Delta Dental issued to insureds were defamatory and disparaging. They claimed that because the statements gave the do-it-yourself or self-application nature of the aligner therapy as the reason for the coverage denial, even though Delta Dental and its members knew that licensed dentists supervised the aligner therapy. Delta Dental responded that the parties' dispute involves the extent to which licensed dentists were involved in the care of insureds who bought plaintiffs' remote access self-administered orthodontic therapy. Delta Dental argued that the challenge statements were substantially true. Truth, of course, is always an absolute defense to a defamation action. To show a defamation claim, a plaintiff must present facts showing that the defendant made a false statement about the plaintiff, that the defendant made an unprivileged publication of the statement to a third party, and that the publication caused damages. Disparagement is defined as statements about a competitor's goods which are untrue or misleading and are made to influence or tend to influence the public not to buy. The definition of disparagement can be broken down into three elements. The statement 1 must be about a competitor's goods or services, 2 must be untrue or misleading, and 3 must have been made to influence or tend to influence the public not to buy those goods or services. Defamatory statements may not be actionable if immunized by an absolute privilege, if shielded under the innocent construction rule, if safeguarded as an expression of opinion, or if protected by a qualified privilege. Whether or not an allegedly defamatory statement is protected by an absolute or qualified privilege is a question of law to be determined by the court. Because the Court of Appeals found that the statements included in the insurance coverage denial letters to the insureds were protected by a qualified privilege, that is, they were required to tell their insureds why they were denying the claim, there was no need to address Delta Dental's alternative arguments. The qualified privilege serves to enhance a defamation plaintiff's burden of proof. The privilege may protect the speaker from liability regardless of the statement's contents. To overcome the privilege, the plaintiff must show not just that the statements are untrue, but that the defendant abused the privilege by intentionally publishing false material or by displaying a reckless disregard as to its truth or falsity, meaning that the defendant entertained serious doubts about the truth of the statement but failed to properly investigate the truth. Plaintiffs presented no evidence that Delta Dental or its members abused the qualified privilege, either by intentionally making false statements or by acting with reckless disregard as to the truth of the challenge statements. Delta Dental and its members were entitled to disagree with plaintiffs regarding the sufficiency of the level of dentist supervision in SDC's alignment therapy. The court concluded that plaintiffs failed to allege malice sufficient to show that Delta Dental and its members abused the qualified privilege and affirmed the trial court's dismissal of plaintiff's claims regarding the defamation and disparagement with prejudice. To state a cause of action for tortious interference with business relations, another allegation made by SDC against Delta Dental, a plaintiff must allege 1. The existence of a valid business relationship, not necessarily evidenced by an enforceable contract or expectancy. 2. Knowledge of the relationship or expectancy on the part of the interferer. 3. An intentional interference inducing or causing a breach or termination of the relationship or expectancy. And 4. Resultant damage to the party whose relationship or expectancy has been disrupted. Plaintiffs' attempts to plead malice were simply insufficient. They failed to provide supporting details beyond conclusory statements of malicious intent to sustain their claims. The court concluded, therefore, that plaintiff's amended complaint alleging civil conspiracy to defame, disparage, and tortiously interfere with the plaintiff's business relationships was properly dismissed with prejudice based on plaintiff's failure to sufficiently allege malice and thereby defeat defendant's qualified privilege regarding the challenged statements. In my opinion, the plaintiffs, in a creative way, sued an insurer who refused to pay claims for dental services by claiming that the letters the insurer issued denying the claims, as required by state statute, were defamatory and maliciously damaged the plaintiffs. The plaintiffs were unable to establish that the statements made in the denial letter were not true, so the defamation claim failed. They were also unable to show a malicious intent because they only issued conclusory statements of malicious intent. The plaintiffs tried to get around the meaning of the contracts that Delta Dental had with its insureds and tried to compel payment of claims not covered by the wording of the policy. Of course, each of their customers still had to pay the bill, and they just didn't have insurance coverage for it, making it a little more difficult for SDC to collect. But that did not give rise to a suit against the insurer, who correctly denied the claims. This video was adapted from my blog, Zalma on Insurance, which is available free to anyone who clicks on the URL zalma.com/blog. You can also subscribe to the blog, and you will be advised of each and every blog posting, usually 5, sometimes more a week. You can also subscribe to the videos at rumble.com and youtube.com. If you found this video and or the blog postings to be useful and of interest to you, please tell your friends and colleagues so that they too can subscribe. You might also wish to subscribe to my locals community and or my Substack publications, which provide not only daily blog postings, but also for a small fee, specialized videos dealing with insurance claims and insurance coverage. Thank you for your attention.